Hi friends, this is Charan and my student ID is EAB2754. Today we are going to be presenting a group presentation on Bhopal case strategy. Charan and Sahu versus Union Court of India. The Bhopal case is also called a Bhopal strategy, and this is one of the most worst industrial disaster happened midnight on 2nd and 3rd December 1984 because of leakage of the methane isocyanate gas from the Union Carbide carbonation plant. Over 3,000 persons died immediately, and after about 25,000 people were died later, and because of the cancer and kidney failures. The Indian government sued a company on behalf of all the claimants of Bhopal tragedy. And central union government empowered Section 3 Bhopal case leakage disaster 1985 to do the case on behalf of all the claimants for an overall case settlement, and the court also analyzed the most reasonable amount of damage that would be fair and unbiased and realistic. And the evaluation of the legal issues has been performed along with tribunal's decision. And coming to section 1, it is associated with a petition filling in unsavory language and presentation, and it has presented the disgracing and demeaning the structure of court of law. And coming to the background of dispute, and the personal attack on court of law has been done, and the reputation of the court has been threatened. And from this moment will continue. Thank you.
Good morning, my name is Pavandeep Singh. Today I discuss the legal issues presented. Every petitioners are case oriented and based on their facts and arguments that are fair in nature. The legal issues that are initiated due to the unsavory petitions was a direct contempt of court resulted in notice to involved petitioner. It is clear that the contents included focused more on the demeaning of the court and its actions rather than presenting the case forward. The another allegation made by the petitioner was that court mix of Western laws, therefore evidence that the petitioner who himself advocates had no respect regarding repetitions of the judiciary body and somebody to country, as well as the petition feels as an individual suggests his rights to charge any any persons or body with fair criticism. The major issues was lack of supporting documents and data suggesting failure of court actions. Thank you.
Hello, I'm one of our group member, and I'm going to talk about in Bhopal case, and my part is section 3. The case unmistakably proposed that the request appeared to be more similar to an individual, and the way that the circumstances made by candidates obviously made for obvious as far as possible, since it did not have enough data or information that effectively saved to the general population. The choice that was at last made by the registry was to not engage as requested, and it was dropped. Besides, it was guaranteed that no more application for open interview prosecution was to be able engaged from similar solicitors. Considering the choice made by the court, it is very well maybe expressed that the activities by the candidate superseded his position and pointed towards the abuse of open interview suits right to exist. So here I come to the end of my part. Thank you.
Everyone, my name is Aman Kumar and my roll number is EMV 3922. and today is presentation about legal aspects of international business and enterprises. And all my teammates discuss a different part of this case. And today I want to speak about the importance of this case in international law. According to von Glan, the mere create the laws and judicial duties and rights. Without self-motive, this can be happen in the future, not only in one country but all over the world. India having a Supreme Court to provide human rights to correct the issue. In this case, petitioner advocate misheard his position due to without motivation. It's opened the possibility to change the law and rights in all over the world, and also it show the comparison between the law and the rights. The major importance can be attached in this case the legal action taken. But instance the petition was dropped, the petitioner was barred from feeling any more public interest, and this can be happen in the future, and so is to change the law and rights. Thank you.
My name is Umar Maheshwara Samaneni. My ID number is KEF2004. I'm going to do conclusion in the occurrence of such a massive tragedy of Bhopal gas. The matter is like who was the responsible and who's not, because it's absolutely inappropriate in a dilemma of thousands of people who get suffer so badly on that night. The tragedy of Bhopal gas leak is still believed the most horrible industrial disaster of the world. In our opinion, it is government duty to check carefully and control such industries in order to prevent such events from happening in the future. It is completely injustice to exclude even a single sufferer from aid. In this case, everyone should not overlook the lessons from Bhopal incident and should ensure the only law restricting the boundary on the liability of such a large-scale catastrophes are declared as unauthorized and unlawful. In this, it was a rightful decision by the tribunal to drop the petition and raise the issue. Reviewing the legislation related to a scenario has prevented such petitions. Thank you very much.